The topic of unfair, deceptive, and abusive acts or practices represents one area of compliance that on one hand can appear straightforward, while on the other hand can be a cumbersome area for institutions to manage, especially when dealing with unique situations along with the new expanded focus by the CFPB. In today's discussion, I'm going to focus on UDAAP and our current environment. This will include a refresher of long-standing principles and a recap of current news. In the world of compliance, we often focus on technical requirements which are supported by a regulation and often official interpretations. This permits us to point to a regulatory citation that helps support the ways in which we do business. However, UDAAP is a different kind of animal, and the financial industry does not have an implementing regulation to which it can turn. Rather, UDAAP is, for the most part, based on a set of principles which by design can be a bit more difficult to get our arms around. Regardless, it is extremely important that UDAAP be considered in our environment as the ramifications can be quite costly. These UDAAP principles are far-reaching in any institution as they can be applied to a wide variety of situations which focus on the life cycle of the provision of products and services. A great resource on UDAAP is the CFPB Examination Manual, which can be found on the CFPB's website in the Compliance section. At a high level, we should all be aware that unfair, deceptive, or abusive acts or practices can cause injury, erode consumer confidence, and undermine our marketplace. As implemented by the Dodd-Frank Act, UDAAPs are unlawful. Just to ensure we're all starting on the same page, here is a refresher. This slide provides a breakdown of the 3 principles of UDAAP. In each column is a description of what the Bureau has described in their exam manual for each principle. At a high level and on the surface, these concepts appear pretty straightforward, are understandable, and really make sense logically. An act or practice that is found to be unfair can be described as something that causes or is likely to cause substantial injury to a consumer that cannot be reasonably avoided. An act or practice that is found to be deceptive can be described as a representation or omission that misleads or is likely to mislead the consumer, with the consumer's interpretation being reasonable under the circumstances. Lastly, the third principle and the most new of the 3 is abuse. An act or practice that is found to be abusive can be described as something that materially interferes with the ability of a consumer to understand a term or condition, which takes unreasonable advantage of, for example, a consumer's lack of understanding. Now, a somewhat new item related to UDAAP occurred in March 2022 when the CFPB updated their exam manual on UDAAP. At that same time, and in conjunction with the exam manual changes, the Bureau released a blog post about cracking down on discrimination in the financial sector. And the thing that caught everyone's eyes was that efforts to combat discrimination would include instances where ECOA does not apply. This was a real game changer as it sets the tone for UDAAP principles to be relied upon in an expanded manner when an examiner observes discriminatory practices in other areas of an institution beyond credit. While you'll see some various CFPB quotes here related to this topic, for me the quote that spoke the loudest was, "Depending on how the conduct occurs, face-to-face, digital, systemic, etc., many individuals may be unaware that they receive disparate treatment or a discriminatory outcome." I think the reason it really caught my attention is because prior to this update, the provision of clear, conspicuous, and complete disclosures, for the most part, served as a strong control and protection from UDAAP. However, even with the clearest of disclosures, as this quote I think supports, a consumer can be unaware of discrimination that has impacted them. Beyond this, while the CFPB hasn't given us anything tangible to work with here, and we do not have prohibited basis data to consider, such as race, ethnicity, or gender in the deposit arena, it remains that this is a very significant risk to manage. Now, taking this a step further, for the most part, the Bureau plugged in references to discrimination within its description of unfair practices, which can include things like denial of access tied to discriminatory behavior, which can result in loss of monetary benefits and other harms that may also cause substantial injury. And in the unfair column, I think the last bullet point said it best: consumers cannot reasonably avoid discrimination. With that said, a takeaway here is that while it does appear that discrimination is often looked at under the unfairness principle, we need to keep in mind that there is also the potential that a discriminatory act can be found to be deceptive or abusive. On this slide are summarized 3 actions that, among other things, referenced all 3 principles of UDAAP. While the CFPB's announcements of each action provides a lot of additional detail, you can tell by a quick look at these that they can be very expensive, as just these 3 cases totaled, in restitution and fines, at least $230 million. Of note, the most recent action and most expensive involved Regions Bank. In that action, it was observed that the bank charged authorized positive, settle negative overdraft fees, which refers to charging overdraft fees on transactions that had a sufficient balance at the time the bank authorized the transaction, but then later settled with an insufficient balance. Related to this, a time lag can occur, for example, when a consumer uses their debit card where the transaction is authorized by a signature versus a PIN. Those signature-based transactions can take typically 1 to 3 days to settle. In this case, it was noted that consumers did not understand the bank's overdraft practices or how they could reasonably avoid those fees. In wrapping up this discussion, I wanted to share some UDAAP considerations that you might think about as you move forward, especially in light of the CFPB's expanded scope and recent enforcement actions. These key takeaways can help you bring your UDAAP program to the next level. A great first step is to perform a deep dive review of your UDAAP policy. Take a look at it with a fresh set of eyes, focusing on where you can possibly build new or improved controls to make your program more robust. When there are product or service changes that are being considered, think about why the change is being made and ascertain its impact. Also, with regards to existing products and services, an institution should always review their complaints as an indicator of possible UDAAP issues. A complaint about a product that relays it wasn't what the consumer expected can be an indicator of UDAAP. Depending on what you find out, adjustments to marketing or revisions to the terms of a product or service might need to occur. The performance of a UDAAP risk assessment can also help an institution be aware of risks that they hadn't initially considered. Under such a review, consider each principle separately. That is, could the act or practice be considered unfair, deceptive, or abusive? Also, as the CFPB is now focusing on discrimination in other areas of an institution beyond credit, an institution might also move forward by considering Reg B and fair housing prohibitions in those other areas. Another item for consideration is whether discretion in pricing is permitted, and if so, how is it controlled? And besides the rate applied to an account, either for loans or deposits. Pricing also includes the imposition of fees, so be sure to consider fees, when they are waived, and why. Consider reputation risk. Sometimes simply considering how a particular change would be construed if it were reflected on the front page of the newspaper can give you a different perspective. Lastly, in conjunction with the CFPB's expanded scope for discrimination, you should also consider expanding your scope to be on the lookout for disparate treatment and/or disparate outcome in all areas of the institution. Having a clear, documented, and robust UDAAP program can serve you well and can help all staff better understand how far-reaching the principles of UDAAP can extend. If you have any questions or would like additional information about UDAAP, please feel free to reach out to us. Thank you.